All right, ready to decode some legal jargon with us today.
Haha, I'm game if you are.
We're diving into the world of warranties today.
Ugh, warranties.
Yeah, those promises and assumptions that are baked into pretty much every deal we make.
Absolutely.
Whether it's that fancy new phone you've got your eye on,
Hmm.
or even just buying a used textbook from a classmate,
Right?
warranties are everywhere.
They are everywhere you look.
And today, you're going to learn exactly what holds those agreements together.
I like it.
And to help us navigate this legal labyrinth, we've got an expert in contract law standing by, ready to break it all down.
Happy to be here.
So let's set the scene a little bit. Imagine this. Your friend, let's call him Max, swears up and down he's selling you a practically new video game.
Okay.
You're stoked, right? You hand over your hard-earned allowance, pop that game in, and
Whoa.
it is scratched beyond belief.
Oh, no.
Max swore it was good as new. Sounds kind of familiar, right?
Yeah, I think we've all been there.
Well, what Max did wasn't just shady. It might actually be a breach of warranty.
It very well could be.
A broken promise with legal consequences. So tell us more about that.
Yeah, so a warranty essentially is a legally binding assurance that certain aspects of a contract are true.
Okay.
You can kind of think of it as a safety net woven into the agreement itself.
I like that.
And the thing is, these warranties, they aren't just confined to, those very formal legal documents with the big words that nobody understands.
Right.
They're everywhere. We encounter them every day, both in common law, which is built on kind of years of court decisions, and also in the Uniform Commercial Code.
The UC.
The UCC, exactly. And that specifically covers business transactions.
So this isn't just some abstract legal idea. These are real-world promises with real-world implications for all of us.
Absolutely. And the thing is, if a warranty is broken, the person who made that promise could be held liable. They could be facing some real legal consequences. So it's really all about accountability, making sure those agreements have some teeth.
I like it. Okay, so let's break down these warranties a little bit more. We've got two main categories. We've got express warranties and implied warranties.
Exactly.
So what's the difference?
So express warranties, think of them as those crystal clear statements, often in writing. They're very explicitly outlining the terms of a deal.
Okay.
Like if a company advertises their sunglasses are polarized,
Right.
that statement becomes like a fundamental part of the contract.
So if those sunglasses arrive and they're about as polarized as my kitchen window, that's a breach.
That is a breach. That promise, that explicit statement about the sunglasses being polarized is often the very reason that the buyer, in this case you, decides to buy those sunglasses.
Right.
It's a motivating factor in the agreement.
It's all about making sure that the product lives up to the hype. Okay, so then implied warranties. These seem a little bit trickier.
They can be a little trickier because they're not spelled out directly, but they are assumed to be part of the deal.
Okay.
So, for instance, if you buy a car, you just automatically assume it'll actually drive. Let's hope so.
You wouldn't expect to have to, like, push it home from the lot.
Great.
But legally speaking, that's an implied warranty. That expectation that the product will function for its intended purpose.
Okay.
Like, if you bought a bike from a friend and the handlebars fell off before you even made it to the end of the block,
Yeah.
that's likely a breach of an implied warranty, even though they didn't explicitly promise it was in perfect condition.
Yeah.
There's this underlying assumption that it would be at least writable.
So implied warranties almost act as a safeguard, even if it's not written down in bold letters for us.
Exactly.
It's like ensuring that base level of quality and functionality.
Yeah. They set those baseline expectations, protecting buyers from faulty or misrepresented goods.
This is where we dive into the sometimes intimidating world of the UCC.
That's right.
I've heard it's got all these rules for how warranties can be tweaked or even completely waived.
Yeah, you're right. The UCC, particularly Section 2316, lays out the ground rules for how warranties can be modified or excluded.
Okay. Now, while sellers can modify or disclaim some warranties, there are specific hoops they have to jump through.
Right.
So, for example, to disclaim an implied warranty of merchantability, which basically means that the product is fit for its normal use, the word merchantability actually has to be stated explicitly.
Wow.
No hiding it in the fine print.
So it's like a legal red flag for buyers, like, watch out, watch out.
Exactly. And then you've got phrases like, as is, or with all faults. These are essentially a seller's way of saying, buyer, you're on your own with this one.
Yeah.
They're signaling that you are accepting the product with whatever hidden treasures or more likely hidden flaws it might harbor.
So let's say I'm at a flea market.
Or,
I spot a vintage action figure.
okay.
The seller slaps an as-is sticker on it. I get it home only to discover it's missing an arm. Am I just out of luck?
In that case, probably yes.
Why?
By accepting those as-is terms, you assumed the risk that that action figure might not be in pristine condition.
Okay.
Well, there you go.
So we've got these express warranties,
Mm-hmm.
those upfront promises, and we've got the implied warranties, the sort of underlying assumptions that underpin a lot of transactions.
Yeah.
But how does this all shake out with express warranties under the UCC? Any surprises there?
Plenty. So the UCC specifically, Section 2313, kind of reinforces the power of those express warranties.
Okay.
It states that these warranties are created when a seller's statement forms the basis of the bargain,
Okay.
meaning it's a key reason why the buyer decided to go through with that purchase.
Okay.
This could be anything from a simple statement of fact, like this antique chair is 100 years old, to like a really detailed product description.
Okay, so it sounds like those express warranties, they carry a lot of weight.
They do, but this is where things get a little bit legally complex.
Oh.
Have you heard of the parole evidence rule?
The what?
Parole evidence rule?
Parole evidence rule. I have not. Tell me more.
Don't let the name scare you. It's a lot less intimidating than it sounds.
Okay, good.
Basically, the parole evidence rule prevents someone from using outside evidence to contradict the terms of a written contract.
Okay, so going back to our friend Max and his practically new video game.
Exactly. Even if Max brought in 20 witnesses to testify that the game was in pristine condition before the sale, if the contract or like an advertisement stated it was like new and it wasn't, that original statement is going to hold a lot more weight than any verbal promises.
So it's a good reminder that in the world of contracts, what's put in writing really does often hold the most power.
Absolutely.
Okay, we've covered kind of the basics of express versus implied warranties. But what about these implied warranties? It sounds like there's a whole other layer when we're talking about merchants, those businesses selling us goods and services.
You are right. Merchants often have a higher standard to uphold under the UCC.
Makes sense. They are in the business of selling after all. So what are those special implied warranties that apply to merchants?
We'll unpack those nuances right after a quick break. Don't go anywhere.
So we're back, and you know those buyer beware signs you sometimes see?
Oh, yeah.
Well, it turns out the law actually has our backs more often than we think,
That's right.
especially when it comes to dealing with merchants.
Especially when you're dealing with merchants, yeah.
So tell us more about that.
Well, merchants under the UCC, they have some extra responsibilities
Okay.
compared to, say, your friend selling a video game.
Makes sense. They are in the business of selling after all.
Exactly.
So what are these special implied warranties that apply to merchants?
Well, there are two big ones. First up, you've got the implied warranty of merchantability under UCC Section 2314.
The what?
Implied warranty of merchantability.
Sounds like a mouthful.
It does have a certain ring to it.
It does.
But what it boils down to is this. If a merchant sells you something, it's got to work like you'd expect.
Okay.
It needs to be fit for its everyday purpose.
So if I buy a brand new coffee maker, it should actually brew coffee,
It should brew coffee.
not just hum at me while flashing menacingly.
Exactly. It needs to be what we call merchantable. It needs to meet those basic standards a reasonable person would expect.
Okay.
A pencil should write, a chair should support your weight. You get the idea.
I get it.
Now, the second big one is the implied warranty of fitness for a particular purpose.
Okay.
And this one is found in UCC Section 2315.
Okay, this one sounds even more specific.
This one is very specific. This warranty kicks in when you, the buyer, have a specific need, and you tell the seller about it, and they recommend a product based on that need.
Okay.
The catch is that product better actually work for that specific purpose.
Oh, okay.
Right.
So let's say I go to a sporting goods store, and I tell the salesperson I'm training for my first marathon, I need shoes that can handle that kind of distance.
Yeah.
They point me to a pair of running shoes, I buy them, hit the pavement, and my feet feel like they're on fire within miles because the shoes are all wrong for long-distance running.
Yeah, that's a textbook example of a breach.
Is it really?
Yeah, the salesperson knew your specific need, a marathon, not just a jog around the block.
Right.
And they recommended a product that wasn't up to the task. They had one job.
Right.
Yeah.
That's rough.
They totally dropped the ball in that situation.
So this is so important because it shows how crucial the context is.
Yes.
It's not enough for a product to just function in some vague way. It has to function for the specific use that the buyer made clear to the seller.
I completely agree. It's all about those reasonable expectations. You made your needs clear, and the seller really let you down.
Okay, so we've talked about what warranties are, but what happens when they're broken, who takes the hit, Is it always just like straightforward seller's fault?
Well, generally, if a warranty is false, the person who made the promise, who gave that assurance, they bear the risk. They're on the hook.
So going back to that unbreakable toy example from earlier, if it shatters into a million pieces, the seller's the one responsible, not me, the buyer.
You got it. It goes back to that principle of accountability that underpins the whole idea of warranties. It's about holding those who make promises responsible for keeping them.
It's all about fairness in the marketplace.
Absolutely, absolutely.
But for those of us who like to geek out on the legal details a little bit, are there specific laws that address this allocation of risk?
You bet. The Restatement, Second of Contracts, specifically sections 151 through 154, they really delve into this very issue. They outline how representations made in a contract, like those warranty promises, determine who bears the responsibility when things go wrong.
Okay, so let's say a warranty is broken. Things have gone south. What can you, the listener, actually do about it? Do you have any recourse?
That's where UCC Section 2714 comes in,
Okay.
the breach of warranty superhero. This section allows buyers to claim damages, meaning compensation, if the goods they purchase don't live up to those promises.
So it's not just about being right, it's about being made whole again.
Exactly. Think of it this way. You bought that brand new video game, you were promised a pristine disc, but it turns out to be so scratched it looks like it went through a wood chipper.
Oh, no.
UCC Section 2714 says you have the right to seek the difference in value between what you were promised, that brand new game, and what you actually received, a scratched up mess.
So you could potentially get a partial refund or even a replacement game.
Exactly. It's about making things right.
Okay, so that's good news for buyers.
Definitely, yeah.
We've talked a lot about the buyer side of things, which is awesome. But what about the sellers? Do they have any ways to protect themselves, to limit their risk when it comes to warranties?
Absolutely, yeah. There are mechanisms in place for sellers to manage their exposure. A big one is using specific language to either exclude or limit the scope of implied warranties.
You're talking about those as is and with all false disclaimers we see everywhere.
Exactly, exactly. Those phrases are like flashing neon signs to the buyer,
Right.
signaling they're assuming a certain level of risk. It's like buying that vintage record player from a thrift store.
Right.
You know there's a chance it might need a little TLC. And by accepting those as-is terms, you're agreeing to take on that potential repair cost yourself.
Okay, so it's a two-way street.
Absolutely.
Buyers need to be aware of the warranties that protect them, and sellers have tools at their disposal to manage their own risk as well.
Precisely.
But even with these disclaimers, are there situations where a seller might still be held responsible? Like, are there times those as-is signs don't hold up in court?
Absolutely. Even with exclusions in place, sellers can't completely wipe away all responsibility. There are certain situations where they might still be on the hook. We were talking about those as-is disclaimers, and those aren't always ironclad.
Right.
There are definitely situations where sellers might still find themselves in some hot water, even with those disclaimers in place.
Okay, so tell me more about that. When do those as-is signs not quite hold up?
Well, one key thing to keep in mind is the opportunity for inspection. Okay, if you as a buyer have a fair chance to inspect the goods before you buy but you choose not to, you're generally out of luck if you try to claim a warranty breach later on for something you should have spotted.
So if I'm at that flea market eyeing that vintage record player, it's on me to really give it a thorough look over.
Exactly.
I can't just assume everything's in working order just because it looks cool.
It's about informed decision-making. The law expects you to exercise some reasonable judgment and take advantage of that opportunity to inspect.
Okay, that makes sense. So you got to do your due diligence.
Exactly.
But even if you do your due diligence, even if you win a breach of warranty case, there's still another layer of complexity.
Oh, there always is.
The question of damages. So tell me more about that.
So even if you prove that a warranty was broken, there's no guarantee you'll get fully compensated.
Really? That doesn't seem quite fair.
It can feel that way, and this is where it gets really interesting, especially in the business world. There's something called the economic loss doctrine.
The what now?
The economic loss doctrine. It can come into play, and a case that illustrates this really well is the Alltech Telecom case.
Okay, the Alltech Telecom case. What happened there?
So imagine this. Alltech Telecom, they purchased a whole bunch of phones from Amway to sell to their customers.
Okay, pretty standard business deal.
Seems like it, right? But then, plot twist, Amway decided to pull the plug on their entire phone operation.
Oh, no. So what did that mean for Alltech and their customers? That sounds like a disaster waiting to happen.
It was not good. Amway exiting the market meant they were no longer able to provide any service or support for those phones that they had just sold to Alltech.
Right.
Alltech was left high and dry, and their customers were understandably furious.
Yeah, I bet.
They ended up losing a ton of money because of this whole debacle.
Wow. So naturally, Alltech took Amway to court, I'm assuming, claiming a breach of warranty.
Exactly. And here's where it gets interesting. The court actually sided with Alltech.
Oh.
They agreed there was a breach. But because of that economic loss doctrine that we mentioned earlier, which basically limits the types of damages that can be awarded in certain commercial cases, Alltech didn't walk away with as much money as they had actually lost.
So they won the case, but still ended up shouldering a pretty big chunk of the loss.
Unfortunately, yes. It really highlights that while warranties are incredibly valuable legal tools, the legal system, as we've learned, is anything but straightforward.
Right.
There are so many intricacies, so many specific rules that come into play when a warranty is breached. And as you see with Alltech, even winning a case doesn't always guarantee a happy ending.
So what's the big takeaway for our listeners today? What should they walk away remembering from our deep dive into warranties?
Well, first and foremost, I'd say awareness is key. Understanding what warranties are, the different types, and how they function is so crucial for both buyers and sellers.
Yes.
Whether you're, buying a used textbook from a classmate or investing in a brand new car, knowing your rights and responsibilities when it comes to warranties can save you a lot of headaches down the line.
I completely agree. We've covered a lot of ground today, from the basics of express and implied warranties to navigating, well, the wild world of the UCC and all those tricky disclaimers out there. Hopefully you're feeling a lot more in the know about how these agreements work and how they impact your everyday life.
That's what we're here for.
And on that note, until next time, happy and informed deal making, everyone.